Good afternoon, and thank you for joining us for an MP webinar covering DEI, top legal challenges, and best practices for protecting your organization. I'm Katie Critter, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service, and a deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today's program, Tawny Alvarez. Tawny centers her practice on the understanding that the employment landscape is ever-changing, and organizations do not have the time or resources to keep abreast of all of these changes. From medical, recreational marijuana's effect on drug testing to the effect of social networking in the workplace, including the effect of the use of mobile devices on wage and hour issues. Tawny has represented diverse clients in a broad range of industries, from small family-owned businesses and nonprofits to Fortune 100 companies across the country. Verrill's deep-rooted history dates back to 1862. Today, Verrill is a full-service law firm with 120 attorneys and 7 offices throughout the Northeast. The firm's attorneys provide award-winning client service to businesses and individuals across the country and around the globe in a variety of areas and industries, including construction, energy, estate planning, food and beverage, healthcare, higher education, manufacturing, technology and telecommunications, and among others. For more information about the firm and its values, visit www.verrill-law.com. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. As a legal disclaimer, this training is intended for educational and informational purposes. While we hope you learn a lot, we are not attorneys and the information should not be construed as legal advice. We will be sending out the recording of the webinar later today, along with the slides. And with that, we're going to hand the mic off to Tawny.
Thank you so much, Katie. I appreciate it. And thank you to MP for having me here today. I'm really excited to be talking with everyone about a topic that I feel very passionate about and that a lot of my work is designed around. So as a labor and employment attorney, my practice includes both advising and counseling clients on policies and practices as to best practices in managing their workforce. And then additionally, I also assist with litigating and defending against claims that may be brought before different fair employment practice agencies at the state level, the EEOC at a federal level, or in state and federal court if it gets to that point. We've got a lot of really interesting things to talk about, from just general diversity, equity, and inclusion concepts and ideas, and then building off of those concepts as it relates to legal issues that can stem from diversity initiatives, and ways in which we can limit any adverse consequences that may be associated with those legal issues. So I always find that it's very helpful for everyone to know the path in which we're going to take, so that if you do have a question, you can ask the question during the course of what I'm discussing, and then I would hope I'm going to be able to respond to it kind of in the moment. So I have the question and answer open. Please ask questions throughout the course of the presentation. And yeah, with that, let's get going. So we're going to start with defining DEI. We're then going to talk about the most common legal challenges that organizations face when we're dealing with DEI topics. We're then gonna discuss communicating DEI commitment to your employees, to third parties, to the public in general. If we have anyone who's in marketing or PR who's on this call, this is going to be really important for you. If you are purely in HR operations, you may want to holler to your neighbor and say, hey, marketing team, come in here. This one's for us too. We're also going to talk about reducing pay equity claims, both what pay equity claims are, and then also kind of ways in which you can minimize being on the receiving end of such a claim. We're going to talk about affirmative action plans, both required under federal law, and then also something that's known as a non-required affirmative action plan that may be created internally. And then finally, we're going to talk about having a DEI culture more generally. So let's start with diversity and inclusion. They are interrelated, and a lot of people will say, okay, there's diversity, there's equity, there's inclusion. These are three separate thoughts. That is not how this works. Inclusion isn't going to occur unless you have a diverse pool of applicants for a position, but you're not going to have a diverse pool of applicants for positions unless you've taken a number of steps to remedy or resolve issues that you may be having more generally on failure to either attract or retain a diverse workforce. Some of the questions that organizations should be asking themselves as it relates to both diversity and inclusion is, one, where are we recruiting from? Okay. And this is a question that's going to come up throughout the course of this presentation when we talk about bias and when we talk about organizations wanting to expand people who are similar to people that they already have because they've had success with those applicants or with those employees. We're also going to look at what types of benefits do we use to entice applicants. Do we have a benefits package, or do we have a culture that is sufficient to attract diverse and non-diverse applicants to our organization? Be very mindful when you're talking to some third-party consultants, specifically third-party consultants who only do diversity and inclusion work, because there's been discussion, and I've seen it on a number of boards and in presentations where they say, anyone can have a diverse work environment. They just need to make the right type of offers. They need to recognize that in order to get a diverse candidate who maybe has a whole bunch of offers, up the pay rate or increase the benefits that are associated with the position. We're going to talk about how that can create some pay equity issues for you in the long term, and why considering other alternatives may be a better fit for the organization to decrease legal risk. Next, how are we supporting efforts for diversity and inclusion within the community? It's not enough to say diversity is something that we are committed to, and then, have people attend one or two diversity seminars or learn more about Juneteenth or have different events within the organization, recognize Pride Month, recognize Women's History Month. Those things are great, but how are you living? What does your culture look like? Do you have the artwork of diverse artists on the walls within your organization? Is your charitable giving campaign one that really is focused in on a diverse community and different type of efforts? All of those speak to your diversity and inclusion and are necessary in many respects, and your law firm is going to rely upon it if you are ever sued for some type of violation of a state or federal anti-discrimination law. All of these aspects will be viewed together to determine, was this just lip service, or do you have a true commitment to diversity and inclusion? As it relates to hiring, one of the things that I would ask that all HR professionals do, and when they're training managers as to hiring is delete language such as not a good culture fit from their vocabulary. When somebody says they're not a good culture fit, or that a person doesn't fit within the culture, in many ways, what they're saying is they're not like us, okay? So what does that mean? Does it mean they don't look like us? Does it mean they don't have the same background as us? They don't dress like us? That's generally what it could mean, but it's such a broad statement that it's hard to tell. Instead, focus in on what really might be the issue. This person lacks communication skills. This person has a much more vibrant personality than what we're looking for in the male clerk. And I think that they would be bored in the position very quickly. In most situations, there are other words that can be used to describe the concept of not a good fit. If you can't figure out what those words are, there's a very good chance that it's based in some type of biased belief. And you need to be self-checking that bias in order to make sure that it's not proliferating kind of within your organization. So those are some aspects of hiring, but then there's also the retaining talent. So how do we keep diverse employees? One thing is, I think, communication, checking in with all of your employees all the time. And I say all the time, but regularly. How is it going? What are your experiences like? What can we do to help you integrate yourself into this organization? It's inviting people to be part of a team. It's appropriate onboarding. So many times when I see lawsuits from someone, they either have been with the organization for less than a year, or they've been there for decades and decades. There's this sweet spot kind of where we see lawsuits, and that's where it's at, is less than a year or multiple decades they've been with the organization, okay? Oftentimes when we lose individuals who have been with us for less than a year and we do exit interviews, one of the things that often comes up is this concept of it's not us, it's a them issue. They weren't happy here to begin with. Okay, well, they accepted the job though. So what is it that happened after that acceptance that then made them not want this job? Really looking in the mirror and reflecting on why someone has left the organization is important, because in a lot of situations, it's not us, it's them. It is a false narrative that you're furthering within your organization. And the longer you further something like this, the more likely that you're going to see some employment-based claim. So my goal here isn't just to point out issues, it's also to help provide answers. So how do we combat the bias that we see so often in employment? Education is one. Thank you all for being here. I think it speaks significantly about your desire to garner more information and knowledge about this topic. Awareness and understanding how bias plays a role in diversity and inclusion efforts. So what does awareness mean? It means awareness during the interview process, during the hiring process, when we're considering promotions. What does that look like? When we're disciplining employees, where's the bias? Do we have bias as to this employee? We're going to talk about it a little bit more as the EEOC guidance from this, but really looking at when you have multiple peers in the same position and you're considering promotion, really being able to explain why you're making the decision you're making is extremely important. Similar to promotions, discipline is also going to be something that you're going to want to reflect on. Am I holding individuals to the same standard without regard to how long they've, without regard to how old they are, or their race, or their gender, or their nationality, all of those things. And finally, termination, which of course is the highest risk behavior from a legal standpoint. Accountability is something that also plays a key role when we're talking about bias. having an organization and leadership that acknowledges that bias is real and that there are steps that need to be taken to combat it is really important. There's also kind of third parties and ways in which they can assist in this process. So I always recommend third party intervention training, so that if you do see someone else exhibiting some form of bias, recognizing how you can assist a person in acknowledging that and taking a step back is also really important. A lot of people would think that these are like really big steps, and from an energy and a capacity and a time standpoint, that they don't have capacity to make these changes. The thing is that there are small steps that can be taken within an organization to help to accomplish this and to increase feelings of inclusion. One of the biggest ways to do it is to decrease the use of words and phrases that have adverse history to minority groups. So some of the words and phrases that I would ask you to exclude from the work environment would be stuff such as peanut gallery. Okay, oh, we got a comment from the peanut gallery. I'm sure you've heard it at meetings before. This is really an inappropriate statement for work because it's referring to the vaudeville area theaters where the worst seats in the house were for people of color in the back. Statements such as spaz, like, oh, that person's just a spaz, or they were spazzing out. This relates to disabilities and it's associated with cerebral palsy, another term that should be removed from repertoire at work. Hooligans is a statement regarding a 19th century cartoon as to Irish immigrants. No can do, a statement that you've likely heard in the past. This is a mocking Chinese pidgin English and something that should be removed. The rule of thumb, it was a 1600 law allowing men to assault their wife with a stick as long as it was no thicker than their thumb. Okay, so when you start repeating terms of phrase, in doing a quick Google to say like, well, actually, what does this mean? And making sure that you're not putting it in writing or speaking about it's really important. People are going to get the slides, but here are some other phrases that you should definitely be mindful of. No offense, but whatever follows that statement is going to be offensive. So don't state the whole sentence. Don't start with no offense, but, and don't state whatever you wanted to communicate. Don't be such a prude. It goes to sexual acts. That was a ballsy move. That's related to genitalia. Wearing the pants. That goes to some sexist statements as to who should or shouldn't wear pants. Don't worry, your pretty little head can be portrayed as something that's directed towards women in a more childlike fashion. Saying that someone is whipped, okay, has negative derogatory connotations regarding race. Lumping people together. Why do all men, why is it that no men can find anything in the refrigerator? Or why is it that all women own 40 pairs of shoes? That's a problem. Those are problematic statements, even in passing. Boys will be boys. It was just a joke. Grow a pair, smile. Some of these really, you know, it's easy to understand why these are problematic, but give, you know, more thought to these statements and make sure that both you and members of your team are removing them from the language that you're using within the office. Let's start talking though about the three most common legal challenges. So we now have this understanding about diversity and inclusion and small ways that we can make a big impact in our work environment. All the things we've discussed so far play a role in the three most common legal challenges. And the first one is how an organization can appropriately market a commitment to diversity, equity, and inclusion without violating Title VII or State Fair Employment Practice Act rules. The second area where we often see legal challenges and issues are pay equity claims. This can be race, gender. Most Fair Employment Practice Act statutes have expanded pay equity claims so that it's not just gender-based, but also includes other protected classes. And then the third thing is affirmative action plans and having appropriate affirmative action plans set up. And if your affirmative action plan shows that you're not meeting expectations in employing a diverse work environment, things that your organization can do to respond. So why do we find ourselves here where we have to have a whole presentation discussing legal issues concerning diversity, equity, and inclusion? Shouldn't it be easy that, you know, we hire people who are best for the job? That should include a diverse workforce, and we shouldn't have to work this hard for diversity and inclusion. It's one of the things that I hear often. The EEOC, however, has done a lot of research here and has come up with the top 6 reasons why a workforce is unable to maintain a diverse workforce. And that's not just to maintain, but also to hire and attract the right people. The first one is what's known as the like me syndrome. So human nature itself, people often associate with other people who are similar minded or are similar in experiences, people that you can empathize with because of similar circumstances. Now, this doesn't mean just that you are the same color, or that you're the same race or nationality. Think about how often people connect with new employees who went to their alma mater or who have connections to the same city or town, right? That's a like me syndrome, and it leads to a tendency to employ and work with other people who are like oneself. This can lead to bias and an unwillingness to employ people who are unlike people in positions of power. The like me syndrome, it can also influence assessments as to norms of performance. So there might be a perception that someone does a job different, and therefore they're less able to do the job than someone who's maybe doing the job the same way you would have done it. All these things can adversely affect equal employment for minorities, for women, for people with disabilities, older workers, people of color. The next aspect is stereotypes. So we spent a good amount of time at the beginning of the presentation talking about biases. In most cases, those biases are going to be presented in an implicit format. Stereotypes, however, are your explicit biases. So stereotypes regarding individuals based off of race, color, religion, national origin, sex, age, disability. Sometimes they can be positive, but oftentimes they're negative and erroneous, and then they adversely affect the targeted employee. So you might be thinking to yourself, well, how is there positive stereotype? Asians are good at math, okay? That would be a stereotype that would be positive, but it's a form of subtle racism. So in an EEO context, you know, there has to be a factual basis for an employment decision, not just a belief based off of other things you heard or understood along those lines. Prejudice is going to be even stronger than a stereotype. So that's going to be your outright bigotry in the workforce. And the EEOC does a good job of recognizing and acknowledging that despite the fact that we've had Title VII now for almost 60 years, that we still have outright prejudice in the work environment. We then see the fourth category, which is an interesting category, and it's perception of loss by persons threatened by equal employment opportunity practices. We're going to talk about this in more detail, but the best way to describe this is reverse discrimination claims, right? People who are claiming that maybe when equality, and I won't even say equality, I'll say equality and not equity, practices are instituted, that they feel as though they've lost something. In my mind, a good example of this is the creation of gender neutral bathrooms, okay? And then you have multiple people coming up saying, takes me longer to get into the bathroom because there's more people who are using this bathroom because now it's gender neutral, right? A lot of people will then refuse to kind of believe that gender neutral bathrooms make sense because they perceive that there's going to be this loss, and failing to identify that there's a multitude of individuals who work with them who likely experience significant pain and anxiety when they have to make a choice as to which bathroom to use because they identify as one gender but may present as another. Ignorance, similar to prejudice, similar to prejudice, this is something that is important to understand, continues to exist and can cause issues within the organization, whether or not it's people who just refuse to acknowledge best practices or that they simply don't understand different issues that are occurring within society. And then there's always going to be other barriers that don't fit within any of these categories that individuals should be aware of. So when we're talking about Title VII and Fair Employment Practices rules, this is where we've seen ESG type board activity, and we've seen attempts to communicate through marketing and PR commitments to diversity and inclusion. And we saw a big uptick in this type of behavior in the wake of Black Lives Matter in the summer of 2020 following Floyd's killing. Here, what we're dealing with is multiple organizations stepped forward and said, you know, moving forward, we are committing to hiring Black individuals and promoting them into positions within our organization. And by X, Y, and Z date, we will have this many people in management positions or in senior positions. And specifically, Wells Fargo and Microsoft were two of the really big organizations that made these type of commitments. And in October of 2020, the Department of Labor, OFCCP, sent a letter to them reminding them that, listen, Title VII protects individuals from race, gender, ethnicity, any of that being taken into account in any respect, okay? That includes in a positive way. Now, Wells Fargo and Microsoft responded and said, yes, we know we're going to do this in a legal way. And we're going to discuss ways that you can have a voluntary affirmative action program and potentially accomplish this. But general statements saying, you know, we're going to, for every open position, for every 3 open positions, we're going to hire 1 individual of color. That is taking race into account in making hiring decisions and would violate Title VII. If this is occurring, you're likely to see what's often referred to as a reverse race discrimination claim. Arguably, it's just a race discrimination claim, but there are standards under the law in which there's a heightened standard if you are an individual who's bringing a race claim when you occupy a majority position, which is why it's sometimes referred to as a reverse race discrimination claim, because there's a higher burden of proof in some jurisdictions to prove that you've been the victim of reverse race discrimination. So how do we manage Title VII and Fair Employment Practice Act risks? We as an organization should never be using the term diversity hire. We should never be mentioning that this individual is part of our diversity initiative or identifying them as being kind of part of that movement. During the interview process, all managers should be reminded of appropriate and inappropriate questions to be asking interviewees. Specifically characteristics that cannot be taken into account in determining qualifications for this period. Anyone who has been in HR for any period of time has likely been in a room when somebody has said, I know I'm not allowed to say this, but I think that the fact that this person is a woman would be really good for the management team. Or I think that because this individual is Hispanic, that they're going to bring a lot more to the management team. Why do we have to be mentioning race or gender or the protected classification? Let's focus instead on this individual's background and experiences, I think, are different from many of the people we currently have in leadership positions. And I think that they'll, help us expand our understanding of X, Y, and Z, right? There's lots of ways to talk about diversity without focusing in on the person's protected classification. Now, I know that there are a lot of diversity there are a lot of consultants who focus in on diversity who would argue that that misses the mark because it's not focusing in appropriately on what needs to occur in order for equity to occur. The problem is the law still hasn't caught up with those societal trends, okay? So when we talk about equity and inclusion, we can talk about having equal rights, but we know that equal rights is different from equity, right? Because we know that they don't look exactly the same, and the law doesn't permit equity to occur because it doesn't permit people who have been disadvantaged over the course of our country's history to receive more than other individuals, despite the history of groups of individuals or people receiving less than what traditionally majority members have been provided. So how do we respond? That, there's a lot to unpack there. The best way to respond is to focus in on EEOC recommendations, and that's a splendid approach. And it requires study, so an organization to study the problem and understand what is occurring within their organization. Plan, so understand the organization's circumstances, which is going to be different for every organization. Lead, it's important for you to have champions in the management role. Encourage, this isn't just a hope, dream, and desire, but you're really working to achieve something. Notice, so you're going to want to be measuring how your activities and your practices progress and change kind of the atmosphere that you're created within the organization. You're going to want to have discussions, so communicate and reinforce that diversity is a business asset, the role that it plays within your organization. Inclusion, making sure that everyone's involved in the process, so not just your diverse candidates, but all individuals. And dedication, which is the understanding that you likely won't be successful, the first month that you institute these type of practices, but that it is a long-term investment that you need to be focused on. So those are some of the ways in which Title VII and fair employment practice claims can come up, and ways in which you can manage those risks. The next topic that we're going to talk about are those pay equity claims, okay? So pay equity claims, and I mentioned it very briefly earlier, are ones that are going to be made against your organization based off of inconsistencies in pay between people within your organization who are at the same level, who have the same background, the same skill set, all of those things. Now, when we talk about pay, it's important to understand that pay is not just wages. And for anyone who followed the US women's soccer lawsuit, they likely, you have a good grasp on this, but we're talking about wages and salaries. We're also talking about deferred compensation and profit sharing plans. We're talking about expense accounts, gas allowance, uniform cleaning allowances, those type of benefits, company cars, bonuses, vacation and holiday pay, premium pay if you're working on weekends or holiday, and then medical, hospital, accident, life insurance, retirement benefits. When we say pay equity, all of these benefits kind of fall within that category. So in the past, we've talked about diversity consultants saying you could attract or retain more diverse talent, you just aren't paying enough or providing rich enough benefits. Understand that what you provide to individuals who you are attempting to bring into your organization who might fit within your diversity goals, those benefits can't just be given to that individual to attract them. But you're going to need to make sure that other individuals with the same job duties or the same experiences at the same level all are receiving the same benefits and pay kind of more generally. So what is and what is not a defense to pay equity claims? The market is not a defense to pay equity claims. It's one of the things that's been causing me a lot of stress lately when I see the rising starting wages at a lot of organizations, is this concept or idea that, what is being advertised as a starting wage, everyone should have already moved the rest of their team up to those levels as well. Because if they haven't, they're now bringing in new employees who are making more than people who have been there 3 or 4 years and maybe have more experience than the new hire, not just with the company, but also in general. Additionally, diversity is not a defense to pay equity claims. So attempts to meet goals, and I'm going to say goals because I hate the word quota. Some people use quota. Please remove that from your diversity programs. That also is not a defense to pay equity claims. So the only aspects or things that in most cases, and this sometimes if it's a state pay equity claim may be different, but from a federal pay equity claim, seniority system is a defense to pay equity claim. So based off of experience, that would help to defend a pay equity claim. A merit system, one employee is really good, one employee is subpar. That would be a second defense to a pay equity claim. A third defense would be a system that measures earnings by quantity or quality of production. So if you have a piece rate system for payment. And then finally, any factor that is other than the protected classification, whether or not that's gender, race, age, under the Equal Pay Act, under Title VII, that would only be sex. But in some states, all those other classifications, if you can prove that it isn't regarding that protected classification, you could have an appropriate defense. So how do we reduce pay equity claims? I've given you the defenses that you can argue, but how do we reduce potentially having one of the claims? One, and the best thing is predetermining salary ranges for a position. So before you even advertise for the position, make sure you're clear on what that salary range is. Do this by assessing current pay rates that you have in your organization versus the market. If you're currently paying significantly less than what the market's paying, and you've taken into account all aspects of pay, so not just wages and salary, but all the other aspects as well, then you definitely should reconsider kind of what is occurring within your organization. If an offer is rejected
to an individual, and that individual rejects the offer, seek feedback as to why the offer is rejected. Is it being rejected because the pay rate was too low, or is there another factor at play? Recognize the costs associated with onboarding as it relates to the increase of pay to your current workforce. A lot of people focus in on recruiting new talent without recognizing that they have a lot of work they need to do to just retain the talent that they have, and that in the long term, that money is going to be better spent for someone who stays for a longer period because of the high costs associated with onboarding. The next thing to consider is regular pay equity audits. If this isn't something that you've ever done before, it is something that I recommend you talk to counsel about. If you perform a pay equity audit without counsel and the pay equity audit shows that you have inequitable pay practices, if you were ever sued under Fair Employment Practice Act and Equal Pay Act, Title VII, all of your data and information you would have to produce in the lawsuit. If you have an attorney involved and it's being done under attorney-client privilege, then in many situations, you're going to be able to protect that data and information. If you do choose to do pay equity audits, however, it's also important that you have a plan, not just that you're collecting data and that you're not going to evolve and make sure that you are appropriately responding if you find out that your practices are inequitable. And then finally, make sure that you have in place policies concerning bonuses, raises, and cost of living adjustments. Oftentimes when an equity audit, a pay equity audit does occur and we find that there is inequities, we determine that it's been created or it's been exaggerated as a result of different systems set forth by different managers where larger raises or bonuses or cost of living adjustments are provided, and the HR hasn't been kind of looped in on that discussion, which is then ultimately creating larger issues within the organization. So those are the key points regarding pay equity, both in minimizing claims regarding pay equity, and then also understanding best practices in order to make sure that you don't find yourself with an inequitable pay system. Let's move on though to affirmative action plans. And we're going to start with mandated affirmative action plans and then talk about voluntary affirmative action plans. So mandated affirmative action plans, these are governed by the OFCCP, which is a department within the Federal Department of Labor. And it's for federal contractors, and it creates an obligation to ensure that applicants and employees during the course of employment and during the application process are able to experience employment opportunities without regard to discrimination on the basis of race, color, religion, sex, sexual orientation, gender identity, national origin, disability, or their status as a protected veteran. And there's significant regulations concerning mandated affirmative action plans, but what the most important thing to remember is that those regulations apply to all terms and conditions of employment. So that's as it relates to recruitment, promotion, termination, and compensation. The affirmative action plan is going to affect all actions. So who is subject to a mandated affirmative action plan, sometimes referred to an AAP? Covered contractors. And then what is a covered contractor, Tawny? It's organizations that have contracts that are valued in the aggregate at more than $10,000, or a contract that's valued at more than $15,000, okay, or a contract that's valued at $150,000 or more. So examples of affirmative action requirements. One, you need to provide notice to applicants and employees that they're an equal opportunity employer. I'm sure many of you do that already, but that would have to be included in your advertisements. You would have to post the EEO as a law poster, kind of with all of your other posting requirements. Again, this is something that I highly recommend all employers do. And it can be with your Title VII notices and your state Fair Employment Practice Act posters. And then under Verrill, which is regarding veteran employment rights, you have to provide notice to the relevant American Job Center or state workforce agency. And that does priority referral for protected veterans, that there's a job opening, that a new job is listed in their job bank. Contractors who have at least 50 employees. So if you're a covered contractor and you have 50 employees and meet the contract thresholds that we've set forth here, you're required to develop and maintain a written affirmative action plan. That's going to require that you collect individualized data from all of your employees and from applicants. And then that data and information is going to be compared with census data in the locations in which you operate to determine whether or not the percentage of individuals of color, veterans, women that you're employing is within a reasonable percentage of statistically what the makeup of that location is. So if you believe that you're a covered contractor and you have 50 or more employees, just be aware that you should be maintaining a written affirmative action program, and that audits can occur in which the OFCCP will come in and ask to see a copy of that plan. If your plan shows that you're failing to meet standards, then you're going to have to set forth actions and procedures that you plan to take in order to meet the threshold that's been set. So that is a mandated affirmative action program, but then there's also voluntary affirmative action programs. A voluntary affirmative action program is an organization would have to make a determination and admit that they have an issue, that the makeup of the organization is not as diverse as it should be. They don't have to admit that it's as a result of their own fault, that they themselves did something wrong, but they do have to acknowledge that statistically there is a lack of diversity within the organization. If not done appropriately, this can create additional exposure and liability if the organization were ever sued under Title VII or a Fair Employment Practice Act. So you have to acknowledge that there's been past discrimination or adverse impact for the group that's in question. And you see that I say as to the group in question because it's much more focused. It's not like a mandated affirmative action program where we look at a whole host of diversity questions, whether or not it's Black, Asian American, women, veterans. All of those are aspects of a mandatory affirmative action program. But for a voluntary, it's more specific as to a specific group. Now, that plan then cannot unnecessarily interfere with the interests of non-minority employees. So you can't say we don't have sufficient minority candidates or minority employees within this role. So what we're going to do is anyone who's in the majority right now, half of them we're going to terminate so that we can replace them with diverse candidates. So that would not be appropriate or permitted under a voluntary affirmative action plan, and also likely would result in a reverse discrimination plan. Additionally, the plan or the program, if you create a voluntary affirmative action plan, it must be temporary in nature, and you have to have a goal. So you have to have a very specific goal in mind, and you have to achieve some type of balance without maintenance. So this is not a 10-year program. This is a 2-year program. It's an 18-month program, but a voluntary affirmative action program should be limited in scope and time frame. Similar to a voluntary affirmative action program, and something that you may have heard of before, is something called the Rooney Rule. So the Rooney Rule is based off of diversity requirements in the National Football League. And the Rooney Rule requires teams so NFL teams, football teams, to interview minority candidates for every open head coach or general manager position. So if there's an open head coach or an open general manager position, at least one of the individuals who are interviewed must be a diverse candidate. And in the 12 years after the Rooney Rule went into effect, the number of minority head coaches within the league increased from 4 coaches to 16, and the number of minority general managers increased from 1 to 8. So if you are in a large organization, a publicly traded organization, or even an organization that has a board of directors, we've seen boards and some shareholders who have begun to request that companies adopt a rule that's similar in nature to the Rooney Rule, and that would be based off of the board membership. So maybe not directly related to employees or individuals in management positions, but instead the makeup of the board of directors. If you're a California employer, you know that there's statutory obligations that require minorities to occupy a certain percentage of the seats within a board of directors. So whether or not it's more of a rule-based or a choice by the organization, or we see more states that begin to mandate this type of behavior, it's important to understand, the Rooney Rule can be seen as a voluntary affirmative action program. Here, however, you're not required to hire an individual. It's just providing the opportunity. This would require that you potentially change how you're advertising positions. The other interesting thing becomes is when you bring in a candidate, how do you know what their race or ethnicity is in a lot of situations? So then do you spend multiple months waiting or trying to pick someone just to interview somebody who may meet one of the diversity requirements that your organization has? That's problematic behavior. So I don't see the Rooney Rule as being something that works well from a traditional sense with most of the positions within an organization, but important to be aware of. How do we measure the success or the failure of affirmative action programs? Points of failure. In most situations, there's a lack of measurable goals. So it's permissible under an affirmative action program and necessary to have those measurable goals, and you have to rectify it for that period of time. Communication to current employees about diversity hires. We talked about that, right off the bat. And then the environment, the physical and cultural environment is such that if you experience any of the issues that we discussed, that the EOC had identified, those 6 points, those are going to be cultural or environmental points of failures. When you achieve success, there's a plan of action that's going to be used to increase diversity of the candidates who you're bringing in. Accountability, if the goals aren't met, questioning why and who's responsible and what changes need to be made in order to meet those goals is really important. And finally, training on best practices on diversity and inclusion topics. You being here, you listening to this presentation today, that goes towards, the best practices and making sure you're limiting your liability here while also trying to create the safest and the most diverse and inclusive work environment possible. So with that, I really thank everyone for their attention during the course of the presentation. I'll open it up to questions that individuals may have at this time. And if we don't have any questions, I'll probably turn it over to Katie.
Awesome. Thank you so much, Tawny. Lots of valuable information on DEI legal challenges. The MP HR team is here to help guide your organization on any HR compliance issues. And if you would like to learn more about how we can assist your organization, please visit our website to set up a short 15-minute call. We would like to thank Tawny again and Verrill Law for their time. Be sure to join us next week on the same day and time for our webinar on hiring and firing in 2022, best practices to reduce legal risk. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar along with the presentation slides this afternoon. Thanks for joining us and have a terrific day.